book talk. And there it is. And Graham will take over the moderating role, so he will introduce Martin.
Thanks, Ed. Thanks to Emily as well for her presentation. I think Martin actually had a question right at the end, so maybe he starts that before his talk. But I briefly introduced Martin. Many of you probably already know Martin. Martin Senftleben is now at 18 months, I guess. Martin has been the professor of intellectual property law and director of IViR at University of Amsterdam, IViR being one of the premier European IP research institutions. Before that, he also taught at the Free University in Amsterdam. He's practiced with Bird and Bird. He's spent time at WIPO. He's taught in every conceivable part of the planet. So Martin has a variety of different institutional perspectives that he brings to all of his work in copyright and in trademark. And what's interesting about the book that he's talked about, it really is bringing together his copyright knowledge and his trademark knowledge. It's a remarkable book. It is, I'll show you from the side, first of all. This is one for dipping into. It's probably not going to be done in one night read, I don't think, but it is a wonderful work. It actually brings together a lot of Martin's thinking over the past many years. And I'm delighted he's going to have a chance to share some of it with us. And we'll do the same as with Emily. Martin will speak for 45 minutes, and then we'll go into Q&A.
Yeah, well, thank you so much for this kind introduction. Let me try to start with the screen share first. So if you could quickly confirm that this actually works and you see the first sheet saying copyright trademark interface. Yeah, so actually I'm very happy to be here, have this opportunity to speak about this new book. As Graham has just explained, it's basically the fruit of quite a long labor. I've really been working on this for several years. I visited Graham years ago when he still was at Oxford, and this was actually also the starting point of our conversation about the topic. So this is the final book, and as you have already seen, yeah, it's quite voluminous, which also gives it multiple uses. So I mean, if you don't feel like reading it any longer, can also be used as a yoga blog, for instance, these kind of things. So it's really in various ways it can be a useful decision to get a copy. The starting point for the whole project was basically not so much something that has to do with a particular legal doctrinal question, but you could say a societal observation or concern. I was wondering why we no longer draw clear boundary lines between artistic works and trademarks, why we don't have lots of discussion or concerns about the fact that more of today's cultural production actually automatically also becomes a brand, a trademark sooner or later. And there are a couple of areas where we see this trend very clearly. So fictional characters is one that I have used very often to illustrate this point. Mickey Mouse, Donald Duck, just to name two very well-known Walt Disney characters, but of course also the American superhero genre is something that you find in the trademark registers worldwide, whether it's Spider-Man or Superman, the Peanuts, Gargamel, the Smurfs. There are also historical examples. There has been a US case on Peter Rabbit and parts of the Peter Rabbit illustrations being registered as a trademark, where the judge, if I remember correctly, makes candid comments on the question whether a British coney could really compete with the Mickey Mouse, the famous mouse in the US, and these kind of things. So there are also, of course, I mean, this is a transatlantic trend. Looking at Europe, Asterix and Obelix, the Daltons and Lucky Luke, Jolly Jumper. I mean, they are all on the trademark registers. I don't know. I think the market share of this particular character, Nintje, or Miffy, as it is called internationally, is perhaps not that big and well known in the US. But I mean, this is a genuine Dutch fictional character taken from a children's book. So also this enjoys trademark protection. But it's not only contemporary art, it's also artworks that are from the museum and that are entering trademark registers to an increasing extent, I would say. So the Scream of Edvard Munch is something that you find on the trademark register. We have the Milkmaids, famous Vermeer painting, and colleagues from France tell me that in France, actually, this has become a relatively famous trademark, which Nestlé is using for dairy products and has registered for dairy products. And in the Benelux countries, we recently had an attempt to register the night watch as a trademark. It was really a bit of an attempt to find out how far can you go with this practice, because the registration was sought for selling the chemical element strontium. So you see really quite an exotic type of good and service. The Benelux Trademark Office refused this, and the Benelux courts did not grant this registration, but at EU level, they had success. So the EU IPO, the European Union Intellectual Property Office, registered this with effect for all EU member states as a trademark. You see similar developments in the area of titles. So these are the Dutch original titles of Anne Frank's famous writings, which had been rejected at Benelux level, but finally registered at EU level as trademarks. And for this research, I did a bit of an analysis what we find. So there is much more of this. So Vincent van Gogh, Rembrandt, Shakespeare, Leonardo da Vinci, and in the area of characters, it's not just drawings, it's also, I mean, Mickey, Superman, Snow White, SpongeBob, Snoopy, Darth Vader, they are all on the trademark registers. So my impression was that we are actually living in quite a greedy age, you could say. When you think about this historically, I think we are living in an era of art production where we leave relatively little unprotected for future generations of authors. Whereas in the past, we could say, well, there was no such thing as modern copyright protection, or at least it expired, and then artistic creations entered the public domain. This is not the case, at least not to the same extent nowadays, because to the extent that trademark protection persists, we would not reach a stage where these creations become entirely free and unencumbered by intellectual property rights. There are other developments. So this is an even more extreme example. This is Banksy's flower thrower, a famous graffiti that you find in Barcelona. There are reasons for his approach because, well, he's an anonymous artist for good reasons, because sometimes this is infringing other people's property rights and so on when you just paint on other people's houses. I would be very happy if he did this on the walls of my house at some point. So, I mean, in case he listens to this recording at some point, please, Banksy, go ahead. I'm happy to send you my address. But I mean, in principle, there might be reasons for not revealing your identity. And he went as far as saying in War and Peace, copyright is for losers. So there seems to be also in the art community, for several reasons, a trend to say, if I'm not a trademark and if my work is not trademarked, then I'm not counting any longer. And actually, this brought me then to a problem statement. I'm not so sure if this is something which a US audience can follow very easily. What I hear very often from US colleagues in any case is, what's wrong with a culture commerce mix amalgam at all? And then people might point to examples like Rhapsody in Blue, Gershwin and United Airlines. And so at the book lounge, which I organized last month, Barton Beebe was making a comment and saying, well, there is hardly any cultural production in the US which not from the very beginning is also approached and planned from the perspective of some commercial angle, merchandising angle, and so on. So this is where, let's say, my doctrinal convictions or approach plays a role, because I think, well, whether we have become used to these practices or not, there is something fundamentally wrong from the perspective of what these intellectual property systems are supposed to actually do. As I see it, copyright law is what I would call a cyclic innovation system. So the author is somebody who is able to use existing cultural expressions as a source of inspiration, perhaps also using building blocks of pre-existing expression to create something new, fresh cultural expression. And for this, we award copyright, but for a limited period of time. Because at the end of the day, the ultimate goal is the enrichment of the reservoir of works that are available to serve as further sources of inspiration. So there is a cyclic process that we want to support, in particular with two central elements, or three if you like, a limited term of protection, and then the idea-expression dichotomy. And if this doesn't help, and as Emily has just explained, exemptions, for instance, of quotations, parodies, I should add pastiche, by excuse, Emily. So there are specific instances where quite clearly copyright law takes the position that the ultimate goal is this constant flow, this constant cyclic movement of cultural innovation, if the word innovation is appropriate in a cultural context at all. I would say that trademark law is quite the opposite. Strictly speaking, trademark law is a bit of the antithesis to this. When we think about the resources that we have for developing distinctive signs, we can say, okay, there is a public domain as well. The trademark developer is somebody who is able to take something out of the reservoir of distinctive signs and adopt this, develop this as a trademark. But from that moment onwards, the trademark system has very much a logic of a static transparency system. So we want the trademark owner to have the chance of keeping protection as long as the sign is actively used in trade, because otherwise the whole purpose of consumer protection, market transparency, fair competition, and so on and so forth would be endangered. So trademark law has this different logic. And this makes cases of overlap really difficult cases from my perspective. The clash is clear, I would say. So here I try a graphical representation of the clash. So you see the cyclic copyright system clashing with the static orientation of the trademark system. I can illustrate this with examples. Term of protection is an obvious one in trademark law. Indefinite renewal is possible. Protection as long as you use the sign actively in trade. Copyright law has a relatively long term of protection, but of course the underlying configuration of the system is that it ends at some point. And then also there is a different limitation infrastructure. This Miffy parody, you see the fictional character Miffy in original Dutch is Nijntje, and then when you have Nijntje, it is possible to make this dark joke about the children's book character as a 9/11 terrorist. So of course this was something that finally went to court, and so this 9/11 terrorist parodist had to fight a war on two fronts, not only defend the case on the basis of copyright exceptions, but also on the basis of trademark exceptions. So because these limitation infrastructures are not congruent, we give artists a particularly hard time when these cases come up. So the problem is, I would say, a wrong incentive scheme. We are not used to taking the approach of an incentive scheme in trademark law. Instead, we focus very much on the rationales I have mentioned earlier: market transparency, consumer protection. Everybody wants this. Of course, I also want this. Nobody can be against market transparency and consumer protection, but I think it's not the full picture. By allowing something to be trademarked. By offering access to the trademark system, we also create an incentive scheme. There is an encouragement of investment the moment you allow certain signs to become trademark sooner or later. So the moment we allow cultural productions to enter the trademark register, we also give a clear signal for brand developers to say, okay, well, pick your work of art or whatever and trademark this and use it as a brand. So it's a bit of an invitation of an incentive scheme. We also see this, practically speaking, becoming more and more important in the field of nation branding or city branding, region branding, whatever. A prominent example being the Norwegian Vigeland case, really a case that I found fascinating, because in this case, we see here two famous sculptures of the eminent Norwegian sculptor Gustav Vigeland, very well known, famous in Norway, really cultural heritage for Norwegian society, you could say. If you ever come to Oslo, or you have been to Oslo, you find these sculptures in the Frogner Park in Oslo. And in this case, before the EFTA court, it was the municipality itself, a public body, trying to register more than 100 artworks of Gustav Vigeland as trademarks after copyright expiry. To the city, this seemed to be a natural thing to do, it seems. When you look at the statements they made during the proceedings, they said, yes, but we are entitled because we as a city, we have invested so much in city branding based on these artworks that the marketing effort that we have made and the marketing success of these sculptures, that's true, that's ours. So we are entitled to get these trademark rights. So that was very clearly the city position. The EFTA court, which is the highest court for the free trade agreement countries directly linked to the European Union. So this would be the highest court for Norway, Iceland, and Liechtenstein when it comes to matters of EU law. The EFTA court applying EU law had very clear points of view on this. The EFTA court said, listen, Oslo, what you're trying to do is commercial greed. You are trying to remove these artworks that have fallen in the public domain a couple of years ago from the public domain. And this is something that we find difficult to accept. So I think the point here in terms of risks is an impediment of the cultural inspiration cycle. So from my perspective, every artwork that is partly removed from the public domain or never fully enters the public domain because of trademark protection is an artwork that is less available, less usable for artistic purposes. I must say that most of the cases that have finally been decided in this area finally are not decided in the wrong way. So if somebody asks me, okay, how many cases really go wrong and judges finally find that an artist is infringing these trademarks, I must say I have difficulty saying that there are many cases which go wrong. But there the question, and that's a bit of a question of methodology, do we actually make in this case a concrete risk assessment by looking at the court decisions and asking, okay, did the courts finally get this right or wrong? Or do we have to make a more abstract assessment by saying we make a risk assessment that is based on, let's say, what happens on the ground? What is the deterrent? What is the freezing effect that we can expect? Because these trademark owners, once they acquire the right, will, of course, I guess, use this right intentionally or unintentionally to write cease and desist letters and tell people what to do and what to say. So I cannot imagine that the municipality of Oslo, after having insisted on their own investment in the Vigeland sculptures, would just allow whatever parody or other ruthless comment on Vigeland's works without taking a position on that and perhaps sending cease and desist letters and so on. And then we must also understand that in this case, it's not the regular trademark dynamic of businesses fighting against each other. In this case, it's basically a trademark owner, a business against an artist and artists are risk averse. We have lots of evidence for this. So in many cases, cease and desist letters may already put an end to the artistic production. There is quite a lot of anecdotal evidence to this. I think this is a wonderful area for further research. So, I mean, for empirical research in the sense of really having lots of interviews with artists and so on, I think that this evidence could be strengthened. There are a couple of studies in the past that support this view that we should look at this at a more abstract level of risk and not the concrete cases that are finally decided most of the time in the right way by the courts. So the point of concern is what I would call communication and definition power. We must understand that the moment we give a trademark owner an exclusive right, we give the trademark owner a stronger position in the conversation, in the discourse concerning this artistic work than all the other speakers. The trademark owner gets a more powerful speaker. So when people are asking me, okay, but then why aren't you against use just in advertising? I'm not saying that use in advertising has automatically the same effect, because use in advertising doesn't give you an exclusive right to tell other people what to say and not to say. So as long as it's only advertising, artistic users can reclaim the work. The moment we really grant an exclusive right, we have one speaker who is entitled to dictate the meaning we give in terms of, how they would call this in cultural sociology, they would say we give one speaker the consecration power to define the meaning of this sign to a substantial extent. I think this is something which in case law is not fully reflected. I have followed from the sidelines, I must say, I'm not that much of a US specialist, but from my perspective, I find it really hard to understand that in the Tam and Brunetti decision, the US Supreme Court spent relatively little time and energy on the question whether a speaker who obtains a trademark right doesn't get a too powerful position in the discourse concerning a sign. So I think these cases, these decisions really were very much focusing on the speech interests of the trademark applicant and did not consider to an adequate extent the detriment to other speakers. I would say what the US Supreme Court is doing here is actually accepting positive discrimination in favor of trademark applicants without considering or considering to a sufficient extent the detriment that would follow from this for other speakers. So that's just a little comment. You find a section about this also in the book. There are more risks, of course. At an even higher level of abstraction, you could say, well, even without any trademark claims being brought, even without a direct confrontation of the art sector with your trademark exclusive right, there is a risk for society as a whole, because the use of artworks in trade ultimately lead to an impregnation of cultural expressions with commercial meaning. In order to maintain the trademark right, you must engage in genuine use. So you are obliged to use the registered sign for the purposes of advertising, selling goods and services. So whatever you do, you have to impregnate the sign with commercial messages. And this as such, I mean, this redefinition leads to a loss of sources of inspiration because we get a redefinition, a devaluation process as a result of this commercial use. So I'm really sorry that I learned that US consumers, when listening to Gershwin's Rhapsody in Blue, must be thinking about United Airlines all the time. I mean, isn't this a horrible thing? You are sitting in the concert hall, you hear this song, you hear this composition, and you think, oh yeah, I know this. That's United Airlines. To me, that's a horrible thing. I mean, this is something. This is something that really affects cultural expressions really to the core, it also means that a later author, a later composer who wants to use Gershwin's Rhapsody in Blue, because there is something in the composition on which he or she wants to comment, or which he or she wants to develop further in some way, this author, this later author, cannot do this without avoiding the United Airlines associations that have been attached to the sign. And this means, and that's another important point, at this production level, cultural expression is non-substitutable. I think this is another thing that often goes wrong in the analysis. People sometimes say, well, I mean, in the cultural area, whatever you do, nothing can go wrong, because if one work is not available, then you just switch to another work. And perhaps at the consumption level, that's actually true. I mean, if I don't have access to Star Wars movies, perhaps I have still a great time watching Guardians of the Galaxy, which are the better movies anyway. So, I mean, at the consumption level, this argument may actually be valid. But at the production level, when we ask the question, to which extent are works available for cultural follow-on innovation? Again, I mean, of course, cultural follow-on innovation will not come to an end, but we will not see these further developments coming from Gershwin's Rhapsody in Blue, because many artists will avoid this particular work as a basis, because they don't want the audience to associate this further work with United Airlines. So there is this devaluation effect which you cannot avoid, and which is happening every time you are granting trademark rights. This brings me to an interdisciplinary aspect of the book. At some point I thought, well, if my concerns are really, let's say, societal concerns, then let's look a bit in cultural science. So I did a bit of studies of aesthetic theory, and there is one argument that I find particularly fascinating, that you can develop starting with Friedrich Schiller's letters for the aesthetic education of man, where Schiller said, well, basically the French Revolution went so terribly wrong and ended in a dictatorship, in a totalitarian system, because people didn't know better. People did not have a full understanding how a fair and just and human society could be taken shape. And so Schiller said, we need some catalyst that educates people to strive for the better society. And this catalyst could be art. So in artworks, we find impulses for better social and political conditions. And so from that perspective, the blurring of cultural meanings based on commercial use is a very dangerous thing to do, because the further discourse, the further artistic discourse on these type of works that could lead to new impulses for the development of society, of culture, will be lost. And this is something that we find in aesthetic theory to this day, after the Second World War and the experiences in Germany with the Holocaust and so on. Theodor Adorno has made very similar statements about the role of art in society. And more recently, in Peter Osborne's philosophy of contemporary art, you find in a somewhat more subtle way, but you still find acceptance of this argument that artworks contribute to societal development and play a crucial role for improving societal conditions. So from that perspective, I think what we are doing by taking a relaxed position with regard to copyright trademark overlaps, it's really a very, very dangerous thing to do. And we don't realize what we are actually allowing in this area. So this was the problem statement and a bit of explanation of background sources of inspiration and argumentation that I use in the book. But there are also solutions. So I find a positive way of solving all this. So there are a couple of proposals for better lawmaking. Tackling the problem can take place at different stages. At the registration stage, we could be more restrictive. I explain in a second why public order and morality, from my perspective, should be used to a larger extent in this area. And then if access to the trademark system is not denied altogether, then of course you can still do things at the infringement stage, either by introducing a gatekeeper requirement of use as a trademark to make it particularly difficult for the trademark owner to build a valid infringement case in the first place, or if you have to correct afterwards, then of course the development of defenses, more robust, reliable defenses, could also be a solution. So let me just, in the last minutes I have, explain a bit what these solutions would entail. At the registration stage, we see in many court decisions reliance on the distinctiveness requirement in trademark law. This is a historical case from Germany, an attempt to register the Mona Lisa as a trademark, where the Federal Patent Court said the Mona Lisa is not distinctive. Is used very often in advertising and trade context, even so often that it has become a customary decorative tool. And so the trademark registration was rejected. You could say, well, fair enough, that's a good outcome because the Mona Lisa does not enjoy any trademark protection then. On the other hand, from a cultural perspective, the line of argument is very cynical. Basically, the court says, the situation with regard to the Mona Lisa is already so bad. The Mona Lisa is used in commercial contexts so often that we can't grant one individual trader a trademark right to this painting. I take it to the extremes. So let's say somebody wants to go and register Guernica for weapons. Guernica being a very strong statement against war. Is this distinctive? Yes, highly distinctive. Is this customary in trade practices? No, I don't see Guernica being registered that often. So if you follow this trademark logic, then we would have to go ahead and register Guernica for weapons. Horrible thing to do, I would say. I come from the German state Hessen, a wonderful part of Germany. If you have never been there, so that's the area around Frankfurt and so on. So you should definitely go. There is wonderful beer in that area. It's not only in Bavaria, but also in Hessen. They have good beer. But there is this one beer producer in Hessen that has used Solveig's song from the Peer Gynt suite all the time. So this is perhaps where the whole book comes from, because every time I hear Solveig's song, I think about Licher beer. But again, I mean, is this distinctive? To my knowledge, this is the only use of Solveig's song consistently for one product. Is this customary in trade practices? No. So I think the trademark right should most probably be granted. So what I'm saying is, I just don't understand why in trademark law, courts and trademark examiners are so hesitant to say more often no. Not just saying, well, yeah, perhaps we have to think about it. And if you use it consistently in trade, and if you develop secondary meaning over time, we will reconsider, we will register and so on. Why is it so difficult for us in intellectual property law to say sometimes just, no, you can't have this? And so a way of saying no would be to say there is something wrong with what you are trying to do. It is wrong to free ride on positive cultural connotations, which you get on top of the trademark deal, because these signs have already positive associations because of their cultural past. Or just saying no because what you are trying to do is against the quid pro quo, the deal in copyright law, which is a protection deal with a limited term of protection. And so it's refreshing to see that the EFTA court, being confronted with this city branding attempt based on Vigeland sculptures, really took this step and said, we have a better solution for this. In these cases, we say that what you are trying to do is against public order and morality, which is, of course, a harsh thing to say against the public body, like the municipality of Oslo. But I think the court was actually right. And I like this decision so much because this was a court who really finally took the position to categorically say, we don't want this. We don't want this practice, and we don't want to give any incentives. At the national level, the Norwegian Intellectual Property Office then took this as a basis and developed the argument further by saying, this is artwork with considerable value to Norwegian society, and the temporal limits of copyright, the public domain principle in copyright, has this status of a fundamental societal concern and consideration. So this is really against public order. The city of Oslo did not appeal this decision, so this then became the final decision. The Norwegian Intellectual Property Office also said this is a free riding on the reputation of the artworks concerned. So I'm saying in the book that we should just broaden the perspective instead of just relying on distinctiveness all the time. When there are these, at least when there are these clear-cut cases, why not using morality and public order to a larger extent? And I would encourage the US Supreme Court to revisit the position taken in Tam and Brunetti. I don't know whether this will ever happen, but based on the book, there's more than enough reason for the US Supreme Court to reconsider the position. Okay, which brings me to infringement claims. There's the famous Dasta decision in the US, where the Supreme Court said allowing a cause of action under 43A of the Lanham Act would be an act of creating a species of mutant copyright law that limits the public's federal right to copy and to use expired copyright. So here, the US Supreme Court basically took the position that trademark protection, in fact, could amount to a mutant copyright law. But, well, honestly speaking, it's of course an open question whether the mutant copyright argument is valid in all cases. Trademark protection, I must admit, is not exactly the same as copyright protection. The infringement criteria are different. In particular, the confusion test is much more context specific than a right in gross as you get it in copyright, like the general right of reproduction. So in trademark cases, it's very often not enough to say, you have copied my work and so you are an infringer. There is more to that. And I'm also happy to admit that in many cases of use in an artistic context, the likelihood of confusion may be something that is difficult to prove. So here I have another Benelux example. You see here an artist who calls himself Cedric. Cedric has made several of these artworks. You see here, he says he is navigating between appropriation art and pop art. So he was using the trademarked Dom Perignon bottle as a source of inspiration and also a motive for his artworks. Is there a likelihood of confusion? Probably not, because of the artistic context and so on. On the other hand, again, what I'm missing here is a clear statement of the courts, statements of the court saying, you know what, and this is a good thing. We will never walk down that road. We will make it particularly difficult for you as trademark owners to bring these cases. Instead, the Court of Justice says, in Europe says, it depends on the degree of distinctiveness. So with this, the court de facto leaves this to the marketing efforts of the brand owner. The court says the public's perception that a sign is a decoration for artistic purposes, for instance, cannot constitute a restriction on protection against confusion when, despite the decorative nature, the sign is so similar to the registered trademark that the relevant public is likely to perceive that the goods come from the same undertaking or economically linked undertaking, which is basically a sponsorship and affiliation argument that has also been criticized in the US. So again, I'm wondering, why can't we take a stronger position on this? I would like to see court statements saying, well, if you bring these kind of cases, the answer is you won't have success. Another example, the German Supreme Court in this case, where Versace brought a case against the producer of floor tiles, and the producer of floor tiles defended its use of the Medusa head by saying, we have taken as a source of inspiration not the Versace logo. We have been to the Glyptothek Museum in Munich, where you find the original from ancient times, and this was the basis for our production. The German Supreme Court said, well, Versace could prove only 5% trademark recognition in the market for floor tiles. So this was not enough to bring a valid confusion claim. If it had been used in the core market of Versace, clothing, luxury goods, and so on, perhaps the story would have been different. So my proposal here would be also considering that in the area of dilution, we might have a much more different, much more negative assessment, in the sense that a showing of taking damage or taking advantage from a trademark is easier to argue in these cases. We have the Barbie girl case in the US, an example, where blurring, tarnishment, and so on was accepted as a claim. We have the parody cases in Europe where blurring, tarnishment, free riding played a role. So again, my point is, considering all these cases, why can't we make it just more difficult? And I think in Europe, we can use as a source of inspiration the Rogers test that has been developed in the US. I know that in recent case law, the Rogers test has been applied a bit more restrictively. Still, for the purposes of artistic expression, I think the Rogers test, even in the more limited version that we have after the more recent decisions, it could be a really important source of inspiration for saying, we should make these trademark infringement claims particularly difficult by requiring explicitly misleading use or deliberately damaging use. So where we have an element of saying the artist really must have an intention of misleading the public, damaging the original trademark. So in a nutshell, and to conclude, what I'm arguing for in the book is not a radical change of the practice in the sense of saying no all the time, but what we need, I think, is an upgrade of the checks and balances. So instead of these flexible, elastic, not really reliable checks and balances we currently have, we need to rethink the whole the whole approach. And have to say, instead of distinctiveness as the core rejection argument, we should have public order and morality as something that is used standard more frequently. Instead of, at least in the EU, not really reliable test of use in relation to goods or services use as a mark, we should have a really strong use as a mark criterion, a kind of extended Rogers test, as I propose in the book, that makes it particularly difficult for trademark owners to bring a prima facie valid infringement claim. And then in the area of limitations, we definitely have to move from an incongruent copyright trademark infrastructure to a fully congruent copyright trademark infrastructure. My impression is that in the US, at least in the area of protection against dilution, some steps have already been taken in that direction because you have a fair use approach there in both areas, copyright and trademark law. In Europe, there's lots and lots of work to be done in that area. So, well, in Europe, we do not have a general fair use provision, at least not across all trademark actions. We have a due cause defense in dilution cases, but on top of that, we only have piecemeal approaches, referential use, non-distinctive use. And we have a strange extra requirement of compliance with honest practices in industrial and commercial matters. So please tell me how artists should be able to know about honest practices in industrial and commercial matters. So if there is a clear indication of a disadvantage of art with regard to with regard to commercial standards of assessment, then we see it very clearly. So the EU legislator has decided to say fair use in the field of arts can only be found if the artist's use is in compliance with honest practices in commercial and industrial matters. From the perspective of my analysis, this is really a no-go. You couldn't do worse with regard to the right standards of assessment. And then finally, in the final chapters, I revisit something which I had planned to do when I started writing the book. When I set out writing the book, I wanted to write a book that would deal with all the IP overlap scenarios that we have in IP law and would come up with a universal solution for all IP overlaps. And I started with copyright trademark, and this is where I ended up. So no worries, I'm not starting an encyclopedia on overlap issues in IP law, but in the final chapter, I try to distill kind of a more general recipe for regulating IP overlaps. And what I'm saying is, if we ever want to solve this, if you agree, problem of inconsistent IP policy that evolves from overlaps, then we must stop giving owners of hybrid right portfolios the chance of cherry picking and creating the best of both worlds by taking those elements of one protection regime to override values and policy decisions in other regimes. And we have to move to a situation where very clearly we say, okay, if you have double rights, so you have copyright and trademark right, you also have double burdens. You have to ensure that both protection systems remain fully intact, also in terms of the policy goals that we want to achieve. So a rights owner who enjoys double protection has an obligation to ensure the proper functioning of all protection regimes involved, which means that the protection that is readily available is reduced. We can use the tools that I have mentioned, stricter access control, more difficult to establish prima facie infringement, full exposure to all limitations and exceptions in all protection regimes involved. And why would we do this? Well, we would do this in order to minimize the attractiveness of overlap scenarios. So I would like to arrive at a situation where IP owners no longer want overlaps, because they know that overlaps will reduce their readily available protection to such an extent that they, out of their own conviction, no longer look for overlaps, because they know that an overlap will mean less IP protection and not more IP protection. And if we achieve this, then we have really solved the IP overlap problem, because IP owners themselves will start thinking about, okay, which type of protection do I really want? And they will no longer look for any kind of overlapping protection. So that's it. Sorry. Normally, when I speak about this topic, I get carried away. Perhaps you felt a bit of this also during this talk. Thanks so much for listening.
Thank you, Martin. It was wonderful. And just to endorse, it really is a wonderful book. There's lots of dipping in as well as reading occasionally from point A to point B for particular things. So if anyone has questions they want to, I have many, but Martin's heard many of mine before, I think. Please raise the hand in the little emoji or emoticon on the bottom right, and I will call on you. Otherwise, I will take a quick crack at some of the ones that maybe are yours. So Ed, do you want to take first?
Sure. And there's my dog. He's assist me with the question. He's very anxious to ask Martin a question. So the public order morality exclusion or limitation to eligibility is a provocative one. It sounds more European naturally. So I guess and one more thing to add to that is sort of the concern for the public does enter into US law, such as in the injunctive relief balancing of the eBay factors. We saw it most recently with Google versus Oracle, where Breyer explicitly mentions public benefit with Android, a new platform like Android. But we don't see it that often in eligibility determinations. Sort of like thinking about the public concern, at least in terms of whether it's at the trademark office, and even less so now after Tam and Brunetti, as you indicate. So I guess I'm just curious, your view that your proposal, at least on the public order morality, is that something that you envision can be exported to the United States?
Well, I'm not the type of person who gives up hope easily. So I still have hope that at some point, even in the US, the courts will understand the particular merits of a public order morality approach. But I must admit, after Tam and Brunetti, that this is, of course, a very difficult argument to make. What I'm wondering about is really whether the US Supreme Court in those cases has given sufficient attention to the question of positive discrimination. There's not only the situation where you discriminate people, disadvantage people, but also where discrimination arises from giving one particular person a much better position than everybody else. And this is something which I think could perhaps, in a future case, lead to a situation where the US Supreme Court also changes course. I'm not saying that this must necessarily be under the heading of public order and morality. I'm sure there are other tools in US law that could be cultivated for that purpose. So I have chosen public order and morality because this is a ground for refusal that, at least in an EU context, is readily available. Also from an international law perspective, it's readily available. So it seems a good vehicle instead of saying we have to introduce a completely new type of ground for refusal in trademark law. I also must say that I hear more and more people saying, yes, I have difficulty with the very terms like public order, morality, and so on. I think this is because in the discourse that we are having also in intellectual property law, we are very much focused on law and economics, these kind of approaches. We hardly any longer dare taking idealistic positions. Where are the people taking idealistic positions? Just saying, I think this is wrong, because from an idealistic position, it's just not a good thing to do. And then perhaps I think we can learn lots from cultural sciences, for instance. So I have used aesthetic theory. I found this really inspiring. I have once given a talk at the University of Frankfurt, very close to my hometown. And one of the commentators had this comment. He said, I found this was a refreshing talk because you basically argued based on an idealistic position and not on a position by saying, oh, I had the numbers, I have the curves, I can show you the right point to find on the curve. So this is the optimum position. Perhaps we shouldn't care less about the optimum all the time, and we should just take the uphill battle and say there are just certain things that we do not want to happen from an idealistic position because we think it's not the right thing for a society, for instance.
I think, Martin, I agree entirely with your comments on Tam and Brunetti. I mean, I think you're going to find more success in the US if you were plowing the Daystar line, where the mutant copyright angle seems quite close to some of what you were talking about. American free speech doctrine is a complete loser. I often joke with my class when I teach that when I got dual citizenship, I expected an injection of some sort that would make me believe in the First Amendment. It's the most fundamental American across the political spectrum belief. And if you're from Europe, it makes absolutely no sense. So you're spot on with that. I have a question on the idealism and whether your idealism, and don't take this wrong, is sort of narrow, right? So you talk about cultural heritage, but it's a very particular view of culture untainted by commerce that you have. I mean, one can have a view that I suppose is equally legitimate about the intermingling of commerce and culture. In fact, Warhol probably, and a lot of pop artists might take a very similar view. So, the question I have is, do you think that the cultural heritage of Oslo would have been better or worse with the city of Oslo having trademark rights, limited rights, just trademark rights, not absolute rights in gross, over the Vigeland statue. Why would the cultural heritage? Do you want a static view of Vigeland? Do you want a dynamic view of Vigeland? Is there a particular cultural lens through which you view that question?
Well, I mean, first of all, I'm happy to admit that. I mean, I clearly take one position in the book, which is based on, yeah, I think it's fair to say, an aesthetic theory, idealistic position on what culture should do for society and what the circumstances are. And from that perspective, the commercial influences are a bad thing. So that's just, I mean, that's really the basis for the whole book. So if you don't buy that argument, that's no problem whatsoever. But then you will have difficulty following the whole line that I have developed in the book. As to the Vigeland case, I think that in this respect, perhaps the book is not the final word, which is not a bad thing, because it can be the starting point of further conversations and also research on what is the impact of trademarking cultural heritage. Is there perhaps in trademark law something to say about additional functions? Does trademark law have a cultural heritage function? So we also have, you know this, I guess, the Neuschwanstein case in Germany that made it all the way to the Court of Justice, where the Court of Justice is saying the state of Bavaria should have trademark rights to the name Neuschwanstein, because then they can ask souvenir and merchandising producers to pay licensing fees, and the licensing fees can be used for maintaining the castle Neuschwanstein, which costs billions of euros every year and so on. So one thing is, okay, perhaps this is right and we can finance cultural heritage in this way, but if we walk down that road, we have to be aware of the costs. And I think the costs are hidden, and the costs are what I'm indicating in the book. I think the discourse in the artistic domain itself will not be as free as it was before. And I think in particular, public bodies should not walk down that road, because whatever they do, they have to develop some commercial use themselves. And from my perspective, in particular, public bodies, if they feel that cultural heritage is an important thing, they should finance this based on state funds and not based on money accruing from the exploitation of trademark rights. So yeah, I think on balance, when we have benefits that we accept that can accrue from exploitation as a trademark, and we have the burdens that we put on the artistic discourse, which is no longer as free as it was before, I would say, then from my analysis, it's quite clear that the free artistic discourse would prevail. But I'm not sure if all other commentators would reach exactly the same result.
It's interesting, though, in terms of how free one is to, so you made the comment, one can't possibly learn or be inspired by Gershwin's Rhapsody in Blue after you've heard United Airlines. I mean, I'm not a composer. You have musical talent. I don't. But it seems to me you could still learn from the compositional qualities of Rhapsody in Blue. And if one wants to be even more provocative, the cultural meaning of Rhapsody in Blue might be more complicated. You might think more tainted, but I think more complicated and maybe has layers that reach other people because it's been intertwined in commerce in some respects. I mean, is it possible that in fact, I have a sense of elevation, if I can take something from United, that it sort of feeds my understanding of Gershwin in a way that then produces a different work when I'm inspired by Gershwin as mediated through United? Is that just too disgusting for you to contemplate?
No, I wouldn't use the word disgusting in that respect. There's not really, no. I wouldn't go that far. The thing is, as I said, first of all, I think that use in advertising is something that we should distinguish from granting a trademark right. I have heard many people also saying, yeah, but often use in advertising draws attention to a certain work in the cultural domain, and suddenly this work has a bit of a renaissance because people go to the music shops or online shops and they are asking for this. Like, I have recently heard this melody in advertising, what is this actually? And then they find out, oh yeah, that's Gershwin Rhapsody in Blue, and suddenly everybody wants to listen to Gershwin Rhapsody in Blue, which is perhaps not such a bad thing. So I see this effect. The only thing is, I guess the discourse should remain open in the sense that artists who want to make a comment on the whole thing can reclaim and can kind of reintegrate this cultural work in the artistic discourse. And there, my problems start with granting a trademark right. As long as it's just use in advertising, I think it doesn't have the same impact as giving somebody a trademark right, an exclusive position for potentially endless time. Because this really gives one person, as I said earlier, more communication power than others. And whether commercial connections are always a bad thing, well, if you look at Disney and so on, I'm not saying that all the Disney productions are bad things. I'm just saying at some point, even Disney should leave these things and allow them to enter into the public domain so that we can see the full potential of the further creativity, derivative of work creativity that can be based on these productions. And actually, that's another point made in the book. I'm still not convinced that it's so much different from what we do in the area of technology. So when Lego, imagine the Lego brick. I mean, I can't imagine my childhood without the Lego brick. But when Lego was seeking trademark protection for the iconic Lego brick, the courts around the world said, no, you can't have this because this is technical functionality and utilitarian and no way. So it was not even a thought. The courts were very clear on that. And when it comes to the Mona Lisa, the courts say, perhaps we don't know. It depends on a distinctiveness analysis and so on and so forth. And another example, has Lego survived this? Yes. I mean, of course they survived this. Walt Disney would also survive Mickey Mouse finally entering the public domain. Come on, they have been the market leaders for so long. Why shouldn't they lose? Why shouldn't they keep their position just because the mouse is no longer exclusively configured and defined by just one company? I mean, if there is anybody who can take the risk of discussing with other artists about the meaning of the mouse, it's Disney. They are the strongest speaker anyway. So I don't buy all the arguments. And on a general level, I think, why is it always an uphill battle to be against protection? I mean, why do I even have to justify that protection overlaps are a bad thing? I mean, it's so obvious that they trouble the policy decisions made in particular fields. So why is this such a difficult thing to argue at all?
That's a broader theme, and when Delta Airlines start using Rhapsody in Blue, there may be a rationale for for under trademark law for stopping them. But that's a whole broader discussion, and I know we've already gone a few minutes over. So please join me in thanking Martin for and Emily for her earlier contribution. It's been wonderful to have both of you present two great books. I hope everyone goes out and buys them and reads them. And learns from them and criticizes and comments where they're right and wrong. And thanks for the two of them for presenting. Thank you all for attending and participating. I hope you got something useful out of it. And Ed, when's our next BookIT event? Is it 2 weeks' time or next week? I should have given you warning.
April 22nd, Sharon Sandine and Eric Goldman, and then April 30th, Irene Kaboli and Jane Ginsburg.
All right, great. So we hope to see you, some of you, back then, and otherwise enjoy the rest of the evening. Those of you in Europe, really enjoy the rest of it. It's already late. Thanks for staying up, and enjoy the weekend. Bye-bye.